Yeah, they say you can't, like, say the surgeon says, oh, the residents are finishing, and he leaves, and 45 minutes goes by. They're like, oh, you can't put the resident out, or the physician out, because it looks like he wasn't here for the case.
Yes, you can.
So, are you really putting the physician out when he leaves?
Yeah.
Is the physician in the room?
No?
If he's not in the room, he's documented out of the room.
Yeah,
Okay.
you can.
He or she, yeah.
Yeah, you can have him in the room and then put his out time, and it'll
Yeah.
show that he was there for the majority of the case, but he's not there for the time he wasn't there.
Same with anesthesia providers, documenting who's in and when, which gets, around like meal times. I know it gets a little sticky because you're documenting 15 people in and out. Observers, making sure those folks are documented as being in the room, because we will occasionally have cases that involve, for example, an implant, and the question is then, was the representative in the room? And if it's not on the surgeonette record, it's not real clear to us 2, 3, 4 years later. And so you're trying to remember a specific case on a specific day, and it gets very difficult. So having that documentation be clear, again, 95% of the time, nobody's gonna look at it or care, but it's the 5% that we're looking at, maybe less, that it becomes really important, really important. And you don't know which case that's gonna be until 2 years out. Questions about that?
I have a quick question, just to clarify.
Yes.
That seems very overwhelming. So every time an anesthesia attending comes in and goes and checks with the resident and leaves, I'm supposed to clock him in and out every single time?
Yeah.
Well, but they do that on their record, so why would I have to?
Well, if their record is clear, I mean, so the other issue that we see is on the anesthesia record. It's sometimes, you see that the anesthesia attending came in, but you don't know how long they were there, that kind of thing. So if you can clock them in and out, that's pretty critical.
I think we have a max of how many people we can actually put in like that top documentation, like before we freeze this, right? Can we only put like 15 people?
I forget what the maximum is.
If you have limitations on the people, obviously the people you would want to start leaving off before you pretext would be somebody who the documentation is somewhere else, right? So if you've got a limit of 15 people, it would be the anesthesia attending, in my mind, that you would leave off if they're documenting that somewhere else. So you want to get the people where you're never going to know anywhere else, it's not going to be written anywhere else when they were in the room and out. Those would be the most critical people. Questions about that?
Just in the court of law though, aren't those two documents gonna be put against each other and say, why does this one say you're here and this one doesn't say you're here?
Yeah, and we might be able to explain. I mean, there's always explanation available. But if they match, that's a whole lot easier. Documentation discrepancies, we spent a lot of time arguing about and trying to make it clear. So the medical record is what we call a business record. Business records are a legal construct. It means that the record was made at or near the time of the events by someone familiar with the events, and they're maintained in a very specific way by a custodian. So if something is a business record, the custodian just signs an affidavit that says this is a business record. The court accepts that, and essentially whatever's in the record is presumed accurate unless proven otherwise. So where you have a record that's got conflicting documentation, now we have to actually argue about which piece of it is true. And we spend a lot of time and money doing that where there's discrepancy.
For years with the electronic documentation, we've been working very hard at trying, once anesthesia gets all electronic, we wanted to get out of our nursing documentation, all those anesthesia things that we've been maintaining for them for years.
Yeah.
Right, like
Sure.
blood loss and that, because that's not our determination, right? So with that being said, then their in and out of the room should be their record, and our record, like Leighton was talking about, should be nursing and nursing functions only. So I think that's what our ultimate goal has been. Are you saying now that that should not be?
No, I think if that's your goal and that's where you're moving, that's fine, as long as it's documented somewhere. But when I go to a case 2 years later, I need to know who was in the room and when, specifically, not just everybody that was in the room at some point during the 8-hour case. And so if that's captured for anesthesia somewhere else, that's great, but it has to be standard that that's where that's captured. And so until it's standardized that this is the expectation, anesthesia is going to capture these things in their documentation, nursing will capture these things in their documentation, until it's standardized, you leave a lot of gaps and bare spots if you're not actually capturing that documentation in the surgeon record. So that's definitely work to do with the anesthesia group to make sure that everybody's understanding is the same. And so, questions about that? Supervision, so supervising surgical techs. If you are a nurse and you are delegating tasks to someone, make sure that you're delegating within their scope of practice, okay? So you can delegate tasks to another individual, but it still has to be within their scope of practice. So for a surgical tech, for example, if it's not within their scope of practice to administer a medication, you can't delegate that task to them, right? So understanding your scope of practice as a nurse and their scope of practice as a surgical tech, or even scope of practice as an RN versus an LPN, that's really important when you're delegating. Are there questions about that? If you delegate a task to someone that's your responsibility and they don't have the skill or the experience to perform it, or are not entitled to perform it based on their scope of practice, that sort of falls back on you and your license. Accreditation. So Center for Medicare and Medicaid Services requires that all hospitals be reviewed and accredited. You can either have CMS come in and do that, or you can hire an organization to come in and accredit you and get deemed status, and CMS says great. So there are about 3 organizations that CMS says are appropriate to review hospitals with and give them deemed status. It's Joint Commission, DNV, and some other one that is very rarely used. We switched from Joint Commission to DNV about 2 years ago, and the reason that we did that, about 3 years ago maybe, the reason that we did that was because we anticipated that DNV would be a more collaborative partner. So with Joint Commission coming, we found we were getting cited and citations for things like there would be a popsicle in a freezer that wasn't in the box, so it didn't have an expiration date, and we'd get a big citation for that, which doesn't really help the mission of saving and improving lives, doesn't really advance patient safety. It's sort of a gotcha, meaningless kind of ding. And so we spend all this time trying to teach everybody the Julian calendar so that you know how to read the expiration date on a box of popsicles. I'm not kidding when I say it was an expired, or not even expired, but a popsicle not in a box, which means we didn't have an expiration date. So we had to write a corrective action plan over a popsicle, okay? This is not helping anybody get their work done well. It's not helping patients. It doesn't advance the ball. It doesn't help us drive process improvement or performance improvement. DNV is very different. DNV comes once a year instead of once every 3 years. So instead of having that 6-month scramble for survey season, we're doing work more consistently throughout the year. DNV is process focused, okay? DNV is all about, I'm not worried about the popsicle, I'm worried about what the popsicle tells us about our processes. So what is our process for monitoring expired foods and monitoring the nutrition refrigerators? From there, how do we calibrate temperature gauges, that kind of thing. So when DNV cites us for something, the citation usually drives improvement across the board. So for example, on our last visit, we were cited for bed scales that were not tested or calibrated on the stretchers over in the Women's and Children's ED. Why does that matter? Well, DNV, when they said we couldn't show that we have these bed scales or these stretcher scales on our preventative maintenance schedule, they said, well, are the scales used for dosing? Like, are the weights from those scales used for dosing? Because if the answer is no, it's not a big deal. The answer was yes. So we're using bed scales to dose pediatric patients, and we never make sure that those scales are calibrated. That's a process failure where we've missed a piece of equipment and getting it in our preventative maintenance plan. That's a citation that actually helps us drive improvement in more than just the bed scale. It helps us identify what other gaps do we have in our preventative maintenance plan and documenting that, finding the equipment on the schedule that we need to review it. Does that make sense? That's why we switched. And so far, we feel like the results have been more positive. Where we're spending our energy on a corrective action plan, we feel like it's fruitful. We're getting quality change out of it.
One of the things that just recently has been addressed to me in reference to policies is, in the past with Joint Commission, we were always kind of informed or taught to use those wiggle room, words, should instead of could, this kind of thing.
Right.
There's no definitive. From what I understand from DNB, if you don't do it, you don't put it in your policy.
That's right. That's the other thing about DNV, it's a little less prescriptive than Joint Commission. So Joint Commission would interpret the conditions of participation in a very specific way and say, this is the way you need to do it. DNV is very different. If the condition of participation from CMS is specific, you need to follow it specifically. Some areas where it's specific would be on restraints, consent forms. Those things we have some pretty specific guidelines. On those cases where the COPs are not super specific, DNV says, come up with your own process, come up with your own policy. They're gonna make sure you're following it. So if it's not something we're actually doing, it's not something we should write down. If it's something we actually should be doing, we need to write it down and come up with the process to make sure that that's happening. So DNV gives us a little more autonomy. The other thing is that with the Joint Commission, you've got two branches. You've got the surveying branch and you've got the educational branch, and they're very, very separate. And so we would hear things, we'd go to the education, and the education would be, you have to do it this way, and then the surveyor would come in and say something totally contradictory, because the two branches did not communicate with one another at all. They were very separate. DNV is very different. When we have education from DNV, or we ask a question of DNV for education or clarification, it's the surveying group that responds. So we're gonna be surveyed to the education we receive. So if they tell us that we have to chain our oxygen tanks individually, we know that's what we're gonna be surveyed to. Okay, questions about that? All right, do you have any questions for me? Any sort of burning items or issues?
I do have a question.
Yes.
Because, I know that they want us to move away from the pagers, and so they want us to be able to we've gotta still be able to contact everybody, and, so I think that the thought process is maybe we'll go to cell phones. Okay, well, what is the legal ramifications of having cell phones in patient care areas, but that's the way we're probably gonna move to start contacting
Yeah.
our employees?
I could answer that question so many different ways. So first of all, just starting from, it's my cell phone, I pay for it. Do I have to do my business on it, right? If you want me to do business on my cell phone, are you supposed to provide it to me? I don't know the answer to that. That's certainly arguable. They could certainly make it a condition of employment that you have a cell phone or some means of communication that you're willing to use. I don't know. The other issue, though, is that our personal cell phones, if you're gonna do any business for the university where you're sharing protected health information, you've got to password protect it. You've got to enable it to be wiped remotely if you lose it. Not everybody's willing to do that with their phone, right?
Right.
And so, that's one of the obstacles in getting people to use their cell phones for business. Having said that, everybody has one, so it makes a lot of sense that we would be using that means of communication, especially since the paging system is not supported. It's going to be defunct eventually, and it's frankly getting there quickly. It's just not supported. They don't even make pagers. They just are continually refurbishing old pagers at this point. Nobody makes pagers anymore. So we've got to move to something. I think the privacy officer would say having cell phones in patient care areas is challenging, because if I'm telling you need your personal phone in a patient care area, I don't know what you're doing on your personal phone in the patient care area. So does it look good to patients to have people on their phones and that's part of the reason for the culture of, yes, 10-5 rule is get your head out of your phone when you're walking down the hallway so people see, you know, faces and it appears more friendly. We're helping people find their way, that kind of thing. So I will tell you from a legal perspective, when there's a lawsuit, for example, I've had people in a lawsuit say, I've had my texts requested based on my work here. So a provider or somebody texts me something, lawsuit comes about later, and my texts are requested my personal texts are requested in a court case, and we have to turn those over. So, I mean, it has implications. Other questions?
On the same lines, do we have, on our consents, did our patients know that they're being monitored with a video in the rooms?
The video monitoring rooms?
Yeah.
Yes. So the video monitoring rooms actually have signage that identifies them as video monitoring rooms and says that the room is being videoed. Sometimes those rooms are used for patients who are not on video monitoring, and so the monitors are turned off, the video is turned off. None of that video is recorded. In other words, it's real time, but if I wanna go back and say what happened, I can't do that. Where patients are videoed, and we do get recordings, are things for like EEGs. So when you're doing an electroencephalogram overnight, for example, they will video and audio record that test and then compare the video to the EEG tracing later to say, here's a spike of activity, what was the clinical picture at that time. There's a lot of signage in that room as well that you're being video and audio recorded.
So like in our ORs, it's real time, but it's not
Yeah.
recorded on
Right.
Another question about consents. So if they do a surgical consent like 2 days before the procedure,
Mhm.
and for whatever reason they think that a family member needs to sign it, but then the day of the procedure, anesthesia does consent and the patient signs it. So how do you feel about having?
I feel real leery about that. So in my mind, the question then becomes, why is the patient not capable of signing this morning? If it's because their capacity has changed from 2 days ago, which happens, I mean, capacity can change over the course of a day, that needs to be documented. I mean, I think it's incumbent upon the anesthesia team to document, you know, patient was already given some medication or whatever the case might be, patient doesn't have capacity to sign this morning, spoke with the surrogate family member. The question will then be, did the patient actually have capacity when the physician got the consent signed? And it's incumbent upon the physician to make sure that the patient that's signing the consent has capacity. So where there's a contradiction, the surgeon and the anesthesiologist need to sort of make sure they're on the same page about, is this the right person to sign this consent? One easy way to fix that potentially is if you don't think the patient has capacity on the morning of the procedure and anesthesia is getting someone else to sign, have that person co-sign the surgical consent. Make sure that person understands the risks, benefits, and alternatives of the procedure, and they can maybe co-sign the surgical consent with the patient. If the conversation occurs, not just here, sign this. Conversation, do you understand? Yes? Would you sign?
Yeah, I just don't think that communication between anesthesia and the surgeon ever takes place.
Okay.
So.
It may come back to bite somebody.
So, but you can technically then do that.
I mean, you've got the two consents. It's worth bringing up to your supervisor to say, do we have an issue? It's worth telling the surgeon, hey, anesthesia had somebody else sign. Do you need us to do anything else? Are you still okay with this? But ultimately, if they decide that's how they want to go forward, if there's an issue, it's the surgeon or the anesthesia provider's issue.
Document that you talked to them. And they decided they didn't wanna get then it'll track that you did bring it to their attention, but they opted not to do anything about it.
Do you recommend that we carry our own malpractice insurance?
For the work you do here, not necessarily. So your malpractice coverage for the work that you do here as an employee is $7.5 million per occurrence. It's the same for physician, nurse, scrub tech, etc.
Is that only if you're following the university policy?
Not necessarily, no.
Okay.
So if you are sued for medical malpractice, the policy, the plan will cover you for work that you do in the course and scope of your employment as a university employee. So if you are a nurse, but you're attempting brain surgery, that's outside the scope of your employment, right? So that's sort of an outlandish example, but an example of you're working in your scope. If you are a nurse, you work here, and maybe you moonlight or take up PRN shifts at a different facility, our plan will not cover you for what you do at a different facility. So you'd need your own coverage, or you need to make sure you have coverage for that other facility. The plan will cover, again, a medical malpractice claim. So if somebody says you were negligent and failed to meet the standard of care, that's what we cover. All you have to do is tell us that you've been sued if somebody hands you papers, and then cooperate with your attorney. Those are the only obligations for you. The plan covers you from your start date to your term date. If you leave, you take a different job, you retire, whatever the case might be, and you are sued 2 years later for something that happened while you were here, the plan still covers you. Okay, so you don't have to buy gap coverage or prior acts coverage if you transition away from the university. The plan does not cover criminal defense. So if you do something and are charged with a crime because of your actions, that's not covered under the plan. We're not gonna hire your criminal attorney. Yeah.
So along those same lines, if a tech is helping the surgeon close and suture, if you're under direct supervision of the surgeon, you're covered or not covered? Because that's outside your scope, basically, I would think, or not?
Well, if the allegation is that you're doing something outside your scope of practice, but you're doing it at the direction of an employee here and with the supervision of employees here, if you're doing it on our patients in our building as part of your job duties, you'd be covered. Even if you're doing something that's maybe not part of your job duties, so you respond to some emergent event and somebody makes some allegation, you're covered, right? So we don't really start parsing, he shouldn't have done that, or that's not his role to decide are you covered or not covered. If you're sued because one of our patients has an injury and they say you were negligent in the care you provided here, that's going to be covered. I've been here for 3 years, and for the 11 years prior to that was with a local firm that did work for the university. So in 14 years, I've never seen us come ask the question, now get the job description, was that really in his scope of practice? Was that really part of his job? And in fact, people in their cases will allege you were working outside your scope, and we defend that and cover that. Okay.
So I read an article once that said, like, say I'm involved in a retained sponge, and I didn't follow, it was found that I didn't follow policies, I didn't use the lap counter bag, or I didn't wand, or whatever.
Right.
So I've heard, or I read this article that said, then the hospital, that you guys would defend me, but then you could turn around and sue me for your loss of cost. Is that
Indemnification.
true?
We've never done it. I haven't read the plan with that in mind, so I don't even know I don't know that there's an indemnification clause in the plan because I've never read it for that. I can look. I know we've never done it.
Okay.
And really, we never admit fault if we settle, right? We make a settlement based on business reasons. We don't admit so-and-so did X and that was negligent and here's your money. We say, well, it's a business decision to settle because the cost of trial would be more expensive. There's a risk of losing. So, without admitting fault, here's a settlement to dismiss the case. Now, if you're buying private plans, you need to read your private plan for that kind of language. You also need to read your private plan you're not gonna get an occurrence-based plan on the private market. It's gonna be claims made. So you will have to buy gap coverage or prior acts coverage for those plans. And you're probably not gonna get $7.5 million. And there's probably gonna be a deductible.
What about like a CMS cites because CMS can cite individual employees, correct?
So CMS typically cites the organization. Occasionally, for something like EMTALA, there will be a fine for a specific physician if the specific physician failed to meet their EMTALA duty. So when we have citations for CMS visits, for conditions of participation, they're typically, they can cite a billable provider, obviously, but they're typically citing the organization. It might be based on an individual's behavior, but.
We had, many years ago, the feds in here, and their surveyor point blank told us that I personally could be fined $5,000, cause in my pocket I had a pair of scissors that was a single-use item that I kept out of the suture removal kit.
Mhm. So it comes down to fraudulent, like fraud, waste, and abuse, so take your compliance modules. But essentially, there are times when an individual can be fined or cited if they're committing fraud, if they're committing fraud, waste, or abuse. I don't know if the Fed was thinking that's an item that's been billed to somebody and you've got it in your pocket. I've not, in my experience, I've not seen personal fines unless it's a really egregious situation, and typically then it's against physician providers because of an EMTALA violation, like the on-call doctor just wouldn't come into the emergency department. That's typically in your community hospitals. Or it's, a Stark law violation or a kickback violation where they're doing self-dealing and self-referral. It's Medicare, Medicaid fraud, billing for services that weren't provided, that kind of thing. Yes.
So just a question. So we nurses sometimes get the drug out of the Pyxis and then didn't use it for that patient, and then just laying on top of the Pyxis and didn't return it and credit the patient.
Mm-hmm. Don't do
What
that.
happened?
Put it back. Put it back. So that's part of the work we're doing. We recently had an internal audit. So University of Missouri System, they have an audit department. They come in and they will audit certain processes. One of the processes they recently audited was our diversion prevention